Hello, everybody. I'm Alan Crone, CEO of the Crone Law Firm. And today we're instituting a new, actually reviving a video series called Ask Alan. And this is going to be Ask Alan, the legal bulletin. And so we're answering some questions that we're frequently asked in consultations and when folks call us. And hopefully this will help people looking for information. So we're going to do this on a periodic basis where we answer a legal question, and I hope it's helpful to you. And if you know anyone who would benefit from this, please forward it to them or share us or let folks know about it. So our first question is, are non-compete agreements legal? The short answer is yes, they're legal. They're not illegal, but they're blunt instruments. If you're looking to enforce a non-compete, you have to show a compelling business interest to do so. They have to be reasonable in time and scope and geography, and they have to be narrowly tailored to a specific end. And what I mean by that is non-competes are evaluated by courts really on a case-by-case basis. And so it's important to make sure that they are narrowly tailored to achieve a particular business objective. And that's what the courts are looking for. In essence, they're looking for, is this non-compete sufficient to prevent the target of the non-compete from gaining an unfair competitive advantage because of their prior association with the enforcing company. Here at the Crone Law Firm, we have been on both sides of these cases. We've enforced non-competes literally across the country, and we've defended non-competes across the country. Different states have different laws and different court decisions, but it basically comes down to that. Most judges are very reluctant to put somebody completely out of work unless there's a compelling reason to do so. And so it's important when you're drafting these non-competes that they're narrowly tailored, but it's also important that you don't just take the non-compete and put it in a drawer and forget about it until it's time to enforce it. If you're relying on confidential information, for example, as your compelling business interest, you need to make sure that your employees know what information is confidential, why it's confidential, that it's well marked, and that you're taking what I call 360-degree measures to make sure that that information is in fact protected, and that you've got non-disclosure agreements with customers or vendors or other people that would also have access to the information. So non-competes are legal, but they're very persnickety. You've got to draft them carefully, maintain them constantly, and cultivate them with your employees to make sure your employees know about them. And from an employee standpoint, if you're presented with a non-compete, you need to have a lawyer look at it and evaluate it and give you advice on the parameters of it, what it means, what it restricts you from, and don't just take someone's word that all those things aren't enforceable. They can be a problem, but there are strategies to help overcome those problems and frankly get you and the enforcing company where they need to be. So I hope that answers kind of an initial question about non-competes. And again, if you enjoyed this, please share it with your friends, share it on social media, and I'm going to go out and get some justice. Thank you very much.